According to the word by Edwin Curley, necessity is the mother of invention. Successfully developed production is the mother of scientific research. A very good morning. I'm glad to welcome you all for the Day 7 2-week International Research Development Program in Advanced Computing 2022, organized by the Department of BCA SRM IST, Ramapuram Campus. I'm happy to introduce our today's guest speaker, Dr. Christo Ananth, for making a wonderful session. He did his PhD in Electronics and Communication Engineering at 2017, Bachelor of Engineering in ECE, Master of Engineering in Applied Electronics. Being a professor in various colleges past 12 years. There were 5 UG scholars and 6 PG scholars under his guidance in the field of electronics and communication engineering. He has published more than 25 researches, 7 books, 28 book chapters, 10 monographs, 40 conferences, and around 60 journals, almost 21 policy documents, 8 granted patents, and etc. He is such a great person, presented and conducted around 45 faculty development programs and numerous training courses. He delivered various webinars, workshops in data science. He is awarded as the Best Faculty, Editors-in-Chief, Biographical Record Holder, Young Scientist Award at
Recording in progress.
2017, Outstanding Digital Innovator Award, Albert Nelson Module Lifetime Achievement Award, Greenpeace Award, and so on. And he is a membership in 133 professional bodies like editors, reviewers in Scopus and Sci-Index journals. Some of his academic achievements are as chief guest, resource person, advisory committee members, and etc. He is actively followed the social pages like ResearchGate, Academia, Google Scholar, Scopus, Loop, LinkedIn, and all other professional social networks. His area of specialization is image processing, electronic devices, wireless networks, and medical electronics. Today is a great day to learn something new. Without delay, now I call upon our today's guest speaker, Dr. Christo Ananth, to take over the session. Sir, it's over to you. The session is yours.
So thank you once again, Professor, for your brief introduction. It was indeed a brief introduction. So once again, I would like to thank SRM Institute of Science and Technology, Ramapuram campus. I would like to specially thank the College of Science and Humanities, of course, the Department of Computer Applications, for organizing this valuable international research development program in advanced computing. I think it is the need of the topic that we are marching forward. Like before, in the days, we used to, present the conference, and that's it. So that is our research. Then we started moving towards journals. Then we started moving around books and then book chapters. Then we decided to go for some quality publication houses, the local, regional, national, and then we went for international publication houses. Then some researchers, not all, some researchers, they go for newspaper articles as well as magazine articles. But talking about quality, maybe we can go for Scopus Index journal publications. We can go for SCI, SSCI, Web of Science index journals. But still, this has been a matter of concern with many of the researchers, with patterns being the modern day tool for the researchers. So that's the reason I just wanted to share with you. And special thanks to the convener, Dr. Agastya, the professor and head of Department of Computer Applications, SRMIST Ramapuram. And special thanks to the coordinators, Dr. N. Vijayalakshmi. She has been through in connecting with me at least for the past 2 weeks. She has been regularly communicating, and it was I who has changed the schedule very recently just because of a clash in my class schedule. So thanks to you, Professor Dr. N. Vijayalakshmi, and of course thanks to Dr. S. Jayachandran, and of course Mrs. S. Sindhu, who has also been the coordinators of this event. Fine. So without wasting much time, let me share my screen. So I hope my screen is visible to you and my audio and video is clear.
Yes,
Okay.
yes.
Yes, sir. Visible, sir. Audio is also audible.
Okay, right. Okay. So this is a topic of concern. Many would have some keen interest about this particular topic. It is patents, which are considered to be the modern day tool, today's tool for researchers. And I would like to dedicate this especially for the students, young researchers, faculty members, our colleagues of this reputed engineering field. And this is Professor Dr. Christo Ananth for you. You can reach me at dr.christoananth@gmail.com. So before beginning any session, before beginning any work, we thank God. As for me, I thank God for giving me this golden opportunity to deliver this useful session, to share my knowledge among my fellow national, international participants, students, and young researchers. So we are going to discuss much more about a short introduction about patents, and I'm just going to go on a simple keyword. Don't go public very soon. Okay, don't go public very soon, and I will discuss about the benefits of patents and deciding if the patent is the right choice, and then how you try to engage the attorney, and then who can apply for a patent, and if you decide not to patent, and then about the types of patents, and we discuss about the standard patent, innovation patent. Of course, many would, some might know, maybe some would not know about it, like the standard patent, innovation patent, and then how you try to search patents in the websites, and about the patent information I would discuss about it. So this has been a topic of concern, cutting edge technological advancements, about the significance of infringement search, and then I would discuss about how to use the competitive product information. And you might think about, whenever you think about patent, you think it in a commercial point of view. Okay, so you think about patent as an investment decision. Okay, so finally I can conclude that patent is not a short term goal, but it is a lifelong asset. Of course, at regular intervals I'll be giving you some short videos about the knowledge in the topics. So this is a short introduction to patents. Before going into patents, I just want to ask you a simple question, a very simple question to each of the participants here. I believe that there are some students, there are faculty members, there are some researchers. I just want to ask you in a simple question to everybody who are present here. How many patents do you have to your credit? Maybe you can use the microphone, or maybe you can use the chat window. It's up to you. How many patents do you have to your credit?
2 patterns.
Yearly twice. Okay. Any more reply? Any more answers from the participants? Any more answers from the participants? The others? Till now nothing. Okay, that's a genuine reply. Okay, right. Not yet. Now only we started. Okay, right. Nil. Okay, good. Happy that you get 0. No problem. Okay, but everybody are still trying. Okay, just one simple question. Yeah, 2 patterns. Okay, right. So at the most you get 2 patterns. Okay, right. Now my next question to you, to those participants who have patterns to your credit, the next question is whether it is published or granted. Whether it is published or granted. Whether it's a national patent, or international pattern? Okay, one granted. I get one reply from Dr. N. Vijayalakshmi. Okay, one granted and one published. Okay, now yeah, the same thing I'm getting. One published and one granted. Okay, one granted. Which pattern you get? Like national pattern or international pattern? International pattern. That's very good. That's very good. Okay, so national pattern you didn't get any grant for it, right? Indian pattern. I think the one published refers to the Indian pattern, right? Am I right? The one published, Professor Anusha said one published. Even Dr. N. Vijayalakshmi said one published. So that one published refers to the Indian pattern, right?
Published is in Indian
Ah,
pattern.
okay, right.
Granted is in and another one is in Indian pattern. We are trying.
Okay, right.
We
Fine.
apply.
Fine. So this is the scenario. This is the scenario. Like many would be thinking, I'm taking from this point that many would be thinking that whenever it has come, whenever you are talking about patents, you don't speak something about publication. You speak only about grant, which means you have a patent number. So only if you have a patent number, it is universally recognized. And even in the Google Scholar, they ask for a patent number. Okay, so the same thing when you're trying to index in popular websites, maybe like SlideShare or maybe ISSUU or maybe Academia or maybe ResearchGate, you get a good research follow and chances that many researchers would try to follow you. My idea is that don't speak about published pattern. Published pattern, it's just like you complete like 5 maybe 10 percentage of the work. Okay, it's not about 50 percentage publication, 50 percentage grant. No, whenever it comes to Indian pattern, okay, 50 percentage doesn't have any sense. Like you finish 5 percentage or maybe 10 percentage, and the remaining 90 percentage is only for grant. Okay, so I'm taking from this idea. So I would rather say a patent is the right that is granted. I repeat once again, it is granted for any device, substance, method, or process that is new, inventive, and very useful even. Even you can take it as a legally enforceable right to commercially exploit the invention for the life of the patent. And your invention, your idea, your product that you are trying to develop should be unique enough, and also it should be inventive enough. It should be so new that it should gain the patent protection. Okay, so that's the key idea of getting a patent being granted. And a patent generally it's a legally enforced right for a device, maybe substance, method, or maybe any process. So something that's new, you get it granted. Okay, so but you should be not fast enough, but you should be slow and steady, and then you have to march forward. So when granted, definitely it will give you commercial rights for any invention, and whatever type of patent you have, like standard patent or maybe innovation patent, will determine the duration of your protection. Okay, maybe it might range up to 8 years, or maybe 10 years, or maybe 15 years, or maybe 20 years. So this is a short introduction about patents. Generally, a standard patent may last up to maybe it might go up to 20 years. Okay, so generally an innovation patent, if you can say, we have up to 8 years. I think the patent that you the recent professors who have mentioned in the chat window, maybe they would have got some innovation patents. Okay, but the standard patent, definitely it might take up to 20 years. It lasts up to 20 years, and an innovation patent is generally being phased out in many countries. Okay, but still some of the countries still have the innovation patent. And if you take in the case of the pharmaceutical field, generally it might last up to 25 years. So that's a advantage you have. Even the applications that normally like the international patent you start with, maybe we start with the Australian patent even. So all Australian patent applications should be filed with IP Australia, and definitely it will meet it should meet the legislative requirements. Okay, so generally whenever you talk about international patents, like this is the reason why I am trying to show the Australian pattern. So the Australian pattern is the first option that everybody would go for. Okay, so generally it will seek professional assistance before applying for a patent, and definitely if you are a SME, then definitely you should have a SME case management service if you do not have a legal representation. Only thing is that with the case of the patents, with the case of the some reputed known patents like Australian patent, you should have a Australian address, okay, or maybe an address in New Zealand. So only then you might get it granted. And definitely when you talk about like different experts, so definitely they would be assisting you with the patent application or maybe like a examination process. So definitely you can ask whatever question you want to, but your idea should be new enough. So maybe you can go for several tools, maybe like you can go for asking any assistance from them. And this is the code line, this is the code line of our today's topic. Don't go public very very soon, okay, because we people, we locals try to rush in for everything, okay, but you should be aware about what you try to demonstrate, what you try to sell, and be sure about your invention, and then you go to public. Okay, so before filing your application, don't decide everything and then you go for filing the application. Okay, so if you want to discuss it to the patent attorneys or maybe business partners, definitely you can sign a privacy agreement, a confidential agreement, and then you start the things, because anything and everything needs procedure, and anything and everything needs a proper agreement, a mutual agreement, then you start up the books. So there are several benefits of patents. Normally when talking about patents, the first question that every researcher would ask is, how much money do I get when I own a patent? Okay. Generally when you take in the case of the Australian patent, so a technical point of view, we have several new inventions, and still the people are earning in millions of dollars. Okay, so the patent definitely will give you the right to stop others from manufacturing, maybe using the invention, or maybe selling the invention. Maybe if you are owning Australian patent, so definitely without your permission nobody can sell, nobody can use it, nobody can use it to manufacture. Okay, and definitely you can own a license for it, you can own a right for your invention, but that's the reason you sign up an agreement. Okay, so whenever and wherever they will show the agreement. Okay, so once it's granted, you are legally enforced to use it. Okay, maybe those people who use it without your prior knowledge, you can take legal action. Okay, and generally with the case of exploiting new technologies or maybe promoting the transfer of technology, so you will have it in the agreement. Also you decide if the patent is the right choice, because you have come up with an invention. Now either you can go for Scopus Index Journal, or you go for SCA Index Journal, you go for Web of Science Index Journal, or maybe you go for a patent also. Okay, so you have to decide what the new device you have come up, the substance, the method, or process. Okay, you should decide about whether patenting is a part of a business strategy. Okay, so you have to decide whether you can own the potential for commercial returns. So definitely the time you have invested, the effort you have given, the money you have invested, so everything matters. Okay, so before deciding upon a word called patent, you have to think in different aspects. Okay, and also patent, when you talk about the benefits, generally it will lessen the risk of IP theft in the markets that you are interested in, and definitely you will have good resources to manage your IP. Definitely a thorough search reveals no other similar technology, like, because maybe we would have come up with an invention, maybe we would have come up with an idea, but when we go for a patent search, definitely maybe that idea would have been patented, would have been granted. Maybe you should rethink in another way. Okay, and you own the invention and you have kept it as a secret, so don't tell this to anybody. Okay, right? So because this has been popular with many institutions, many organizations. Maybe you have something called the staff performance. Okay, right? They tend to ask you so several details. Okay, right? So maybe when it comes to patent, they will ask you the title, where you have submitted, when it was filed, when it was registered, what are the documents you have submitted. Okay, and it does not happens with many institutions, but some institutions what they do, they tend to get the idea out of it and they try to develop it. So it doesn't happen with many institutions, so forget about it. But still, I would rather suggest, whenever it comes to patent, don't disclose it unless it is being granted. Okay, and do your research and ensure that you apply the appropriate form of protection, because it's a secure means to give a right for your patent. And definitely whenever you have the patent being filed, then definitely you should have the necessary documentation. So what you do before, when deciding definitely whether a patent is the right choice or not, what you do, you go for a provisional application. You don't go for a general application, but you go for a provisional application. Provisional applications, when you talk about, in the case, it's less, very cheap even, and definitely you can get it in the earliest possible priority date even. So when the patent attorneys discuss about your idea, go through your idea, then definitely they will say whether your idea is okay or not. Okay, so the professional application you can go for, but of course that this provisional application doesn't give you the full protection of the patent. Okay, but maybe it can give up to 12 months. Okay, but you can decide within this 12-month period, you can decide whether to go for it or not. Okay. So this is the relaxation time that you get. Even with the case of the IP Australia, okay, like we have PCT application even for your invention, and definitely it will give a quick indication about whether the invention can be patented, and definitely across the countries you can enjoy the protection. So this has been a topic of interest in many SMEs, okay, small scale as well as medium scale enterprises. The business concerns are taking patent as a right. Okay, so maybe we researchers, we faculty members are working in the institution, but still patent has been the idea in many business concerns. And for the first time applicants, so definitely you should ask the help from a senior. Okay, so in this case you ask it from the patent attorney, so definitely we can increase the chances of success, and definitely we will have like a toolkit. Okay, we'll have definitely a step-by-step guide about what to do, when to file, okay, when you should approach the patent attorney. Okay, so definitely we can engage the patent attorney. We can definitely we can feel comfortable, we can feel confident about how to proceed further, how we can go through the next subsequent steps. And then who can apply for a patent? So definitely the inventor, or maybe a group of inventors. Normally in your case, maybe you have 5, some might be 10. Maybe in the case of China, you have like developed countries like China, you have 10 authors, maybe 10 inventors, 15 inventors for a single patent. But this pattern, it will be a standard pattern. Definitely it's great to look into. The idea would be really good, and the person who has legally obtained the rights to the invention from the inventor. So even you can be a sole inventor, or maybe you can get the idea from somebody, get the rights from them, and you can be owning a patent. And maybe you can be a SME company, or maybe organization, or maybe any freelancer even, but still you should belong to a particular concern. Okay, and you should provide, maybe with the case of the Australia, you should have an Australian address or maybe a New Zealand address. So that's the key point. So for each of the cases they have certain rules, but pattern is common, but with each of the countries the rules differ. Okay, and a firm or partnership is unable to obtain a patent. Maybe the partners in the firm or maybe the partnership, definitely they can work together, they can jointly add their own names for owning a patent. And chances that you might decide upon this also. Okay, if you decide not to patent, okay, So normally we people try to rush up and push it in some way that it gets granted, but you shouldn't do that. Okay, so you have to consider all the aspects. Okay, and you might decide that the patenting is not the best option for your some certain circumstances. Maybe you can keep this as a trade secret. Okay, maybe when you whenever you try to make a decision, think maybe like 100 times before making a decision, because normally we try to rush in forward and we make uh, some crooked decisions, but it doesn't suit you in always, because patent is something very risky. Patent is something a serious concern. Okay, when you copy somebody's idea and you somehow just for the sake of institution case, or maybe just for the sake of surviving in the organization, you go for a patent. It doesn't help you. It doesn't support you in all aspects. Okay, so you should be very careful when you're dealing with patents. Okay, I still remember one case when in a famous institution, one particular assistant professor was trying to, give this patent, submit this patent, and it got published. Okay, the national patent, it got published, and maybe within 1 month or so, the original authors were giving a claim, were submitting a claim. Okay, and this claim came straight to the organization, and they immediately fired that particular person. So you should be really careful when you deal with patents. So it's not a plaything that you try to submit some articles in a local journal and then you finish all the stuff and do that. Okay, but you should assess the risk of someone discovering your invention. So definitely you should think it in all aspects, reverse think it, and then you do that. Okay, so you also need to consider the consequences of someone else independently developing the same invention. Maybe you have decided an idea, maybe somebody else decided the same idea, then you should think about it. And another thing is that you can openly use and publish details about your invention. Maybe disclosing an invention, maybe it's a chance that maybe somebody will not do that. Okay, maybe somebody will see about it and they will stop about it. Okay, so while no one would have a commercial monopoly on your invention, definitely your competitors would be free to use their own benefit even. So that should be a matter of concern. You decide, you think about it like 100 times, 1,000 times, you think about it and then go for it, else don't go for it. Maybe you can keep it as a trade secret. So this is what I'm talking about. Normally just like Australia, just like US, just like a German pattern, you have a standard pattern as well as an innovation pattern. But now normally in like days back, maybe weeks back, I saw that several of the innovation patterns have been phased out. Okay, you can no longer apply for an innovation pattern, but still the innovation patterns which have been granted, it still remains the same. Okay, but what you do, you can consider filing a provisional application, or maybe you can seek a international protection. Okay, there's no much difference in cost. Okay, but it is all about the type of invention that you are bringing it to the public. Okay, maybe if you are a SME, uh, generally you can access this SME case management service, and definitely if you do not have any legal representation, you can go for SME case management service. So definitely we will have a subject matter expert. We definitely they would be assisting you about how you make the application, how you go through the examination process, what you should search for before going for the filing, and then you tend to do that. So standard pattern, as I told you, it will give you protection up to 20 years from the filing date of your application. Very recently, I got one patent renewal notice. So, but still, with the case of pharmaceutical sciences, it can last up to 25 years. And the invention, what you are trying to establish, it should be new. It should be an inventive step. Let me tell you a real-time scenario. Like, what I worked in Gulf, like. 2 3 years back. Okay, right. So like 2 years back, I started to know thoroughly about patent. Okay, like I was bringing in some 5 ideas to the patent attorney. Okay, so all surprisingly, all my 5 ideas was rejected by the patent attorney. So I was bringing into a conclusion that whatever idea I should do, it should be broad enough. I should be thinking in all ways, uh, different aspects I should think, then I should decide to come up with the thing. Okay, and after the 6th time I decided to discuss thoroughly with the patent attorney, then I came to a conclusion, then we went for the patenting the idea, and it got granted. Okay, so you should think about this one. It's a there is difference about the invention that you are trying to bring, and inventive step that you are bringing in an invention. So you should know about it, that an inventive step means that invention is not the obvious thing to do for someone with knowledge and experience, but you should think about the aspects of patenting, the filing and the registration, and what protection it offers over others. So that you should do. Okay, and your invention, definitely it should be different from the existing technology, but there should be some good basement, standard background knowledge when you are coming with a patent. So before the standard patent can be granted, definitely the application will be examined. So definitely, according to the examination, we would seek the professional assistance. So this is innovation patent. It's a sub part of the standard patent. Okay, so definitely for an invention with a short market life, then definitely we can go for an invention patent. I mean innovation patent. As I told you, it was phased out back in when you take in the case of IP Australia. So definitely it was phased out like August 2021. But definitely those patents which have been already granted, then definitely you can enjoy the services up to 8 years. Okay, you can offer you can enjoy the protection inventions. So generally when you talk about like innovation patents, so definitely we will enjoy all the services of the standard patent, but still the substantial innovation, or maybe substantial idea, is very important for an innovation patent. So this is actually a sample of what you get. Okay, a certificate. Generally, they follow certain rules, regulations, and procedures even before certifying. And the examination of the innovation, definitely only if it is examined, only if it is requested by the patentee, then the examination process goes through. Okay, maybe if you take in the case of the Australian patent, like whenever you go through the rules and procedures, they grant it first of all, and then you pay, and then it goes for the examination. Okay, so only if it is required to examine, you pay for the fees. Okay, the patentee will not be required to pay for the examination unless it is being requested. And this I have been telling you many times, you have to search for the patents. Okay, like you have to search for the patents before going into applying, because you have to conduct a very thorough search. Okay, a very thorough search, and definitely you can avoid wasting the time and the money even, because sometimes you waste your money, you waste your time, but that idea was already patented, was already granted. Okay, so searching for the patent information can be complicated, it can be a time consuming process, it can be costly even. So what you do, you try to approach a IP professional, let them do for you, and then you can come up with the idea. Okay. And definitely, as I told you many times, so maybe you can get the assistance of SME, case management service, if you do not have any legal representation. So maybe if you are a firm partnership, you can ask for the SME management service. So this you should do that whenever you go for a Google patent search. Okay, you need to ask two things to you. Can I protect my invention with a patent? So this you should be asking this. Okay, okay, and does my invention infringe someone else's patent? So this two questions you should ask. Can I protect my invention with a patent, and does my invention infringe someone else's patent? So this you should be asking them, and definitely if you get answer for these questions, so definitely you can determine what type of IP you try to own, and you can check whether your intellectual property right has not been infringed, or maybe you can update the product information on your competitors for research purposes. So it's very essential that you try to search for a pattern and then you ask some some relevant questions and then you come up with the answers. So I can define this pattern to be a prior art. So which means that the information or maybe the data that you get on in the inventions have been publicly disclosed. Okay, so it becomes an open-ended platform. So anybody can post questions, anybody can claim for it. Okay, so this what you should do. So you should go for a prior art search. So definitely you can decide upon what technology generally exists, what type of idea you are actually doing, whether it is matching to the advanced technology or not, that you can decide upon. And maybe you can go for pattern cooperation 3D database. Maybe you can go for both the national patents as well as the the international patents even. Also you can go for searching it in the scientific journals also. Okay, normally, like not all cases you go for a pattern search, but also you go for some reputed websites like Google Scholar, where you get access to the libraries. Okay, like the Google libraries, scientific journals and other publications, the existing products. Of course you use the internet, maybe there are some databases even. So you can go with the a thorough search maybe before going into filing. And you should get this information from the patent database. So when you are going to search for it, maybe you can go for a Google patent search. Maybe you can find a similar invention. Maybe sometimes a broader search needs maybe some amount of money. So maybe you can get it assistance from the IP professional even. And definitely we will have a small percentage of the world patenting activity. So that's what you go for a broad pattern search. And make sure you don't infringe someone else. So this is something that you should be really very careful about it, because whenever you try to introduce a new product, then definitely whatever you do it, maybe it should not affect the others, because they would be coming up with an idea even. So you should go for a patent infringement search for every product. Okay, so what you do, maybe just as an example I'm giving you. Okay, I'm just giving you a particular example. Maybe if you are making wooden coat hangers or maybe plastic plates, so definitely it's unlikely that you will infringe someone else's work. Okay, so that's, as I told you, whatever idea you should do, it should be new enough, and maybe you can enjoy the services up to maybe 20 years or maybe 25 years. So you come up really new. Okay, so don't come up with some modification and then presenting the idea. And this is what I'm trying to discuss with you. So it's a cutting edge technological advancements, maybe in AI, maybe in ML, uh, like several computing technologies that you are going to make with your invention. Definitely you should go for a patent infringement search. Okay, so technologies that you should come up with a new concept, but it should not infringe someone else, but still it's not been expired even. Okay, so you should go for a thorough patent infringement search, and you make up an idea to ask some questions like, is the product made up of number of components, or maybe you should conduct a search for each of these components, so that you should decide upon, and whether it is infringing about the claims made by the other patentees. So that also remains as a very great challenge in the case of the cutting edge technological advancements. Also, with the case of the thorough search, even maybe like a software program for controlling the X-ray machines, maybe which classification it falls to, maybe data processing, or maybe image processing, or maybe medical image processing, or maybe medical equipment. So that also you should go for. And also you decide about coming up with an outstanding patent application on your particular product. So uh, those applications which have not been filed, it's not come into markets, which means you can go for it. Okay, so only if it is granted, it will be showing up. So you should make sure that the whenever you are going for public, you should think many times. And when you go for the public, when you discuss this with the attorney, when you go for several processes, you should be fast enough, because whatever search you are conducting, it is the search of the patents which has been granted. Okay, you don't get a search about patents which are under publication, or maybe under grant. Okay, so you should think about in that aspects, and then you should go for it. All right. Pattern searching, definitely it can be complicated even. So definitely searching does not guarantee that your product does not infringe someone else's pattern. So that's what I told you. Maybe whatever search you are conducting, okay, it is the search of a granted pattern. Okay. So if you do that, then you need to know, carry out an infringement search about the detailed technical information about your product, or maybe whether you can make it up, or maybe you can intend to make your product even, where you can sell, or maybe intend to sell your product even, and when your first made product was made, now when you actually try to sell your product, okay, whether you can no whether all the patentees can use it, maybe the third parties can use it, whether SMEs can use it, whether an institution can use it, whether an organization can use it, that you should go for. Before going into this one, I think we should go for a short video. And I'm asking the organizers of the event, I've still got something to share with you. Do you have any event subsequently, or can I continue further? Because I have at least some 15 minutes to go for.
No issues, sir.
No
You
issues.
continue, sir.
You
Continue.
can continue, sir.
Because if you have any works, then you can tell me. Maybe we can.
No issues, sir. You can
No
No
continue.
issues.
issues.
Okay, okay. Right. So generally, when using this comparative product information, generally we can design about what you go for an idea about the pattern, and definitely you can get a step ahead of your competitors even. So definitely you can commercialize anything which is not covered by the patents claims. So your idea is something different from the others. So maybe you can do that. You can go for a commercialization about which areas they don't cover even. So maybe you can discover a significant area, or maybe you can go for a use for a product that is not covered by a competitor's pattern. So definitely it is all about the use of technology and how you bring about a inventive step. Okay. So that bringing about that inventive step really takes some time, and then you discuss this with the patent attorney, then you come up with the uh, conclusion. Okay. So maybe you can determine about who owns a patent. We can go for a patent register to determine who owns a patent. Okay. Generally, you can go for transfership. That's what I'm telling you. Maybe I can be the inventor, or maybe I can get the right from a sole inventor, get the rights, and then I can be owning a patent. Okay. So once notified about the change, the details are recorded in the patents register. So they follow some procedure, like maybe Patents Act of 1990. So it is going to provide protection for the patents register. So maybe it can decide about who can own a patent, and which documents are actually permissible, which documents are not permissible. That also it shows about that. And also all security interests, like mortgages over a patent, definitely it should be recorded by a secured party even on the PPS register, personal property security register. So definitely with the PPS register you can determine whether there is a mortgage on over the patent or not. And it's going to give a legal security register even. It is showing you the records of all the particular mortgages even. So definitely when you take in the case of a company which is trying to own a patent, you can go for searching a company charge information, maybe a fees that is applicable for the Securities and Investment Commission, to determine whether the mortgage has been recorded or not. And determining whether a patent is valid, and just because a patent has been issued doesn't mean that it has been valid. Okay, so we have to do for relevant prior art search. Okay, so that's what we go with the several examination process. So when this prior art search comes into light, then definitely, so which means your pattern is not that up to the mark. Okay, so it's very important that you come up with an idea, but it should not go infringe someone else's work. Okay, so prior art search is very, very important. And there are 6 myths I would like to share with you. You would get interested about this one. This has been a mind voice with many researchers. A pattern will cost me hundreds of thousands of dollars. Okay, it doesn't. It's a myth. Okay, don't believe in this myth. Okay, like prices vary, but the cost of drafting, filing an initial patent application, what you call it to be the provisional application, definitely it will cost like $3,000, maybe $6,000. So maybe converting this to a full patent will be roughly similar. So don't believe this type of method, myths even. Okay, so it's not going to cost you hundreds, thousands of dollars even. So don't believe this one. There is no point in getting a patent. Okay, because the big guys will just steal my idea. Okay, you might have an idea, like you have decided upon an idea. Maybe some big concerns, big companies, big organization, they already have the idea. So uh, thinking about pattern, you cannot think about it. It's not a myth. Okay, it's actually a myth. Okay, don't believe this one. Maybe some people may worry that big corporations will steal their idea. Maybe you would have seen in the movies. Okay, they don't have enough money to fight in the court. Okay, so but if your invention is protected by a patent, maybe that they will deter many people from trying to copy it. Definitely, if a big corporation infringes in your idea, so definitely having a patent with all the mutual agreements, having the documents in your hand, definitely you get a seat in the negotiating table. Okay, so whenever you take it to the court even, so definitely if you have the proper agreement and the proper procedure, so definitely you can make that big corporation go down. Okay, and then I can get a worldwide pattern. So nothing is global. Nothing. There is no such thing like a worldwide pattern. Okay, based on your business plan, you have to seek for a patent protection in each country where you expect to sell your product, and you cannot get a global, worldwide pattern. Okay, maybe you can get an international pattern, but it's not worldwide. Okay, and a patent attorney will steal my idea. This has been even I thought about it. This one. Okay, why I should discuss this with a patent attorney? Okay, because patent attorneys, they abide by the rules, they abide by the government code of ethics. Okay, because they have to be ethical, they have to be courteous, they have to be well informed about the decisions they make. So whatever fraudulent way they do, they are into it. Okay, so they have their own industry code of ethics, so which means whenever they try to forward them from acquiring this IPR, definitely it is a conflict of interest. So don't think patent attorney will steal your idea. Okay, so don't think about it. There are patent police. Okay, just like we see in the video. Okay, so once you have secured a patent, you will need to do your own checking. Okay, so it is not infringing someone else's work. So don't think like there is a patent police who's checking 24 hours, 7 days a week. Okay, not like that. You have to do that your own search, and you have to keep your eye on the competitor product. Okay, definitely searching in the internet every now and then you see that somebody else don't copy your ideas. Okay, and also a patent, whenever you publish it, whenever you get it granted, the next day you don't get money. Okay, so maybe it is all about the agreement, it is all about the procedures that you try to do. Okay, so it's all about the commercialization that you try to make forward with the case of the patent. So you are unlikely to receive business offers just because you have secured a patent. Okay, but still, in a broader aspect, you have to have a big business plan for commercializing your idea, and definitely you will have enjoy some protection. And pattern can be considered as a commercial tool. So maybe every decision that you try to make, when to get a pattern or maybe where to secure a pattern, definitely uh, you can turn this into a money. But the thing is that your ideas should be broad enough, your business plan should be broad enough. Only then don't think about making money just from the start. Okay, maybe you commercialize it, then you come up with a good business plan. Okay, so seeking a pattern, maybe it takes some time, takes some money even. You should weigh the cost, and then according to the business plan, you can think about commercializing. And pattern can be thought about as an investment decision. You have to think maybe 10,000 times before making it as an investment decision. Okay, because pattern, when you use the resources appropriately, definitely the business plan would be layered, and definitely in the market it would have a widespread use. Okay, so the money might be better spent on marketing, maybe for advertising, maybe for increasing the production, manufacturing, and for the product development even. Okay, so there are several ways to protect your IP, like trade secrets and non-disclosure agreements even. So think about, maybe on the next level, you can think about patent as a investment decision. Okay. Right. So thank you, Professor Agasthyar. There was a message from you. Okay. Maybe if time permits, if the situations prevail, definitely we will have a offline presentation also. But still, I'm not in India, so that's a thing. I go in an online way. And definitely we can go not as a local way, not as a regional way, not as a national way. We can go for international way of patterns even. That's what I told you. Many would have got your Australian patterns granted, but still some would go for US pattern. I went for US pattern. I went for a German pattern. I went for an Indian pattern even. My Indian pattern is going to be granted very soon. Okay, so you can decide upon whether you seek the patent protection overseas. Okay, so that it's a good thing. But once again, I'm giving you the idea that there is no such thing called worldwide pattern. There is no such thing like global pattern. Okay, so you have to decide upon the countries. Maybe if you are going for a Japanese pattern or maybe Korean pattern, then you should go for translation. The idea is the same, but the thing is that the procedure differs. Okay, so this is what I'm trying to tell you, many times. Okay, like there is no such thing like global pattern offering global protection, but the thing is that you come up with the idea and accustomed to their rules and regulations. Okay, so patent can be considered as a lifelong asset. So once you have a patent, then definitely it should be an asset. Definitely, maybe you can also sell this to maybe another person even. Maybe you can license it, and patent, definitely you can raise funds from the local governments even. So if you have decided not to patent, maybe you can go for a trade secret. But I really wanted to share with you, and this has been for my code line for everybody. Don't expect others to do all the work. Every time you say to yourself, I have to initiate, I am entirely responsible, and I am the sole one, and I have to give my own promotion. And just imagine whenever you are caught up in a very difficult situation, even with the case of bringing about a pattern, okay, an idea, never, ever give up at any point in your life. Okay, imagine like you are a frog in the mouth of your crane. Just catch hold of the crane, just go the situation further. Definitely, you will have a bright future. So I wish every researcher, every colleague, every faculty members, every student here to march forward with your research, with good research as well as academic follow. Maybe you would have several friends in Facebook, WhatsApp, Twitter, in Telegram even, but still you should have a good academic research social follow even for a brighter strengthening technical collaboration. So thank you once again, dear coordinators, the members of the event, for organizing such a valuable program. And definitely, if there is part two of the event or maybe any other event, I would rather feel happy to get associated with. Thank you.
Thank you so much, sir. Now I call upon Dr. S. Jayachandran, Assistant Professor, Department of Computer Application, to tell a vote of thanks.
Thank you, Lakshmi ma'am. Good morning to all. Saying thank you is more than a good manners. It is a good spirituality. It has been such an honor to be part of this wonderful event. On behalf of the BCA department, SRMIST Ramapuram campus, I would like to extend my heartfelt gratitude to our esteemed chief guest, Dr. Christo Ananth, sir, professor. Thank you, sir. And I sincere thanks to head of the department, Dr. Agasthiar, professor, SRMIST Ramapuram campus, who handled the event throughout. And wide round of applause and thanks to all the participants who made the event at a memorable one. Finally, I would like to thank our coordinators, Dr. N. Vijayalakshmi, Mrs. S. Sindhu, and Mrs. P. M. Kavita ma'am, to encourage a success grand event. Thank you, one and all.
Thank you, sir. Participants kindly fill the feedback form which is available in the chat box. Thank you, Christo Ananth, sir. Thank you.
Thank you, ma'am. Thank you.
Thank you. Thank you, Christo Ananth, sir.
Thank you, sir. Thank you very much. Thank you.